name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today, we're going to be talking about support, a very interesting issue in family law designed to educate the viewing audience. So please subscribe to our channel. A lot of people will call me up and say, "We got the whole thing worked out, Mr. Goldman. No problem. I'm gonna I'll get one kid and she gets one kid, or she's gonna have the kids for a week and then I'm gonna have the kids for a week, and it's beautiful, and we're splitting everything and no support, and that's it." And they want to know, if we do that, can we be assured that the court will go along with it? Well, generally speaking, if the parents work out a workable arrangement between them as to how we're functioning with these kids, and the arrangement makes any kind of sense at all, the court will probably support it. But you do have to understand one thing. Just because you're sharing the children does not nullify support. It might, but in most cases it won't. Why do I say that? Well, I'll tell you. The support is based on a few factors. Yes, it's based on how many overnights with mom and how many overnights the kids spend with dad. But it also is based on how much money does dad make, how much money does mom make. So even if it's a completely split situation where the kids are 182 and a half days with mom and 182 and a half days with dad, and they share overnights during those days throughout the 365 days of the year, there's still going to be support if one person makes more than the other. If one person during that same period of time is making more than the other, there's going to be support going to the one who makes less. Now, it may be very nominal support. Maybe they make similar amounts of money. Maybe the support will be 50 cents. Who knows what it'll be, but it'll be something. The only time there's not going to be a support is when the overnights are exactly the same and the parties happen to make the same amount of money. And you can say, "Well, gee, Mr. Goldman, what's the odds of that happening?" Well, I'll tell you, better than you think, because you have, let's say, two people. They meet because they're working the same shift in the same place. So that's how they meet. They end up getting together. They end up having a child. These are two people that have the same job, that may well make the same amount of money, and because they work the same shift, they split the child as best as they can. That's a situation where there might not be an allocation of support, but in most cases you have to understand there's going to be support because somebody's going to be making more than the other, or the parenting time, though called 50-50, is not always going to be 50-50. I've had instances where people will come to us and say, "Here we are, I'm not getting any significant support," and I'll look at the judgment, and the judge will say, "Well, I think you're not getting any support of any significant amount because you've got a 50-50 custody. And you make about the same amount that he makes, so there's very little support." And then I get the added, "Yeah, but even though he's supposed to have the kids on an alternating week, he never takes them." Oh, now we have a problem. In other words, the court order doesn't reflect the reality. The 50-50 isn't actually being exercised. Well, if that's the case, there's a remedy. You've got to contact your lawyer. You've got to have your lawyer file a motion to change and modify the parenting time to reflect the reality. And when the parenting time is modified to reflect the reality, guess what? Support's going to change based on the change in parenting time. But until such time as you take that step, the court doesn't know that the 50-50 isn't being observed. So that's something to keep in mind. And if you have any questions about your specific case, of course, let us know. We'll be glad to help you out.